Hello and welcome to another episode of intelliTALKS. Today we have a special guest, one of my friends from, let's say, the attorney part of the business, and I really like, and I cannot say this in a very nice words, so I'll just say, Rich, welcome.
Thank you so much. Really good to see you on here. Thank you for having me on your show.
Thank you for joining the show, Rich. And yeah, we were just chatting a bit prior to this episode, to this recording. I have to ask, and this is for all the audience and myself as well. I like the new look, so maybe you can tell us a little bit about the beard.
Oh yeah, of course, because I'd say most people in the space that know me haven't seen me like this. This just came about over the summer, and I went on a family beach vacation for a week, and I didn't remember to bring a razor. And so I grew a beard in that week while I was away, and I came back and I thought it looked pretty good, and people kept telling me that they liked it, so I kept it. And so now I guess there's a new me with a beard.
Yeah, there we go.
And so many people that see me don't recognize me. People I know well, they just look right through me. It happened a lot when we were at Amazon Accelerate. Just a lot of people were like, I was like, hi. And they're like, hello. I was like, oh my God, wow, it's Rich. So don't be surprised if some guy with a beard walks up to you and says hello, and it just might be me.
Yeah, there we go. And yeah, personally, I like the new touch, and it's stylish, if that's the term, but it's very nice. So yeah, thank you for sharing that, Rich. That's great. Yeah,
absolutely.
All right. For everyone that doesn't know, Rich is the founder of Goldstein Patent Law. Am I correct on that one, Rich? I don't want to. Yeah. So all right. So this is very important, and he works with Amazon sellers like us, like myself as well, to protect the products, the brands, and to also protect the trademarks, and also resolve IP issues with Amazon. So this is very powerful because usually it's how to put this. You don't want to get on the wrong side of the law, so you have to stay on the good side. And in order to stay on the good side, you have to have a good attorney and someone that actually knows what he's doing. And this is why we have Rich here to give us maybe some tips and tricks. But also sometimes you may, break some glasses. Also, you need a very good attorney. So, Rich, again to the rescue.
Yeah. Yeah, well, and if you can't have someone that knows what they're doing, then at least you can have me.
Yeah, well, with a beard. So that's two for one. Yeah, Rich with a beard. All right, Rich. Let's start from let's say ground basis.
Okay.
Why do you think people need a trademark? Let's see. Yeah.
Well, on Amazon, there's a couple of reasons. I mean, first of all, in general, trademarks are for preventing your competition from confusing your customers into thinking that they're dealing with you when they're actually dealing with them. It's to prevent you from losing sales to others that imitate you and imitate your branding. And so trademarks are all about preventing a likelihood of confusion. So if someone had a very similar name to your branding, for example, then that could mislead people. People could be misled into buying their product instead. So on Amazon, they protect against things like that when you have brand registry. So when you have brand registry, you're able to stop other sellers from using your brand name. And essentially, in order to get brand registry, you need to have a registered trademark. So it pays to get a registered trademark so that you could stop other people from tricking your customers with similar branding, and so that you can get brand registry.
Yeah, and also I remember back in the days, I started on Amazon in 2017. So back in the days, there were two ways of obtaining a trademark. One was by yourself, so there was a nice way of doing it yourself. You didn't need a lot of, let's say, backs and forths. But nowadays, the only way to obtain a trademark is through a certified attorney. Am I right, Rich?
Close. I mean, it's kind of like if you're an individual, you can still apply for a trademark on your own under your individual name, which isn't typically the right way for most businesses. Most businesses, they have a corporation, they have an entity set up, and that's actually the entity that's controlling the nature of the products and services. So that's the entity that should be applying for the trademark. Now, if it's corporation, then it absolutely, you need representation by an attorney. You can't act as the attorney on behalf of the corporation to apply for a trademark. So yeah, that's mostly correct. But if you're an individual, like for some reason you're selling products under your own name, I'm selling products I make in my garage under Rich Goldstein, then then I could actually apply for it myself. But then actually that doesn't make sense because I'm an attorney. So, but the point is, like, individuals could still apply for trademarks in their own name without an attorney. But for most sellers, that's not a reality. And in truth, it really is never a good idea to apply for it on your own. There's just so many nuances to it that if the brand has any value at all to you, it pays to have an attorney handle it. I mean, overall, it's going to be a couple $1,000s maybe for a trademark registration. And it really pays to have someone with experience that can steer the process, because it's a very simple process, but it's highly nuanced, where having the right experience can steer the direction you go a little bit to the left, a little bit to the right. That can make a big difference as you get further along in your journey.
Exactly. It's maybe I didn't put in the right words, but it's pretty much like driving. If you're driving straight, you just have to hold the wheel and it may go straight.
Right.
But the minute you have to turn a left or a right, that's when you need someone like Rich. You need a powerful attorney there to help. Yeah.
Yes.
All right. So trademarks, that's something that I am a fan of. I always start with a trademark whenever I start the brand, so I check for the trademarks to be available.
It's absolutely the best practice is to file a trademark application when you start a brand. One reason for that too is that it takes about 1.5 years these days to get a registered trademark in the US. So you might as well start as early as you can, because you're going to be waiting a while to have the trademark office even get to review it. So it pays to do it as early as possible.
But if you do it through IP Accelerator from Amazon, you can benefit from it earlier, right? I mean, you can help them through there as well, right?
Actually, you don't need IP Accelerator to. What happened a few years ago, that was the way it worked. But for the last couple of years, you don't need to be working with IP Accelerator firm. Once you apply for the trademark, you can go into your account and submit for brand registry, and then they'll send a code to your attorney, who will then share it back with you, and then you enter it back into your account, and then they'll give you brand registry. So you don't need to be working with an IP Accelerator attorney to do that. You just need to follow that process. And just, by the way, that weird process of sending you a code, etc., that's their way of knowing that the person asking for brand registry is actually the same person as has applied for a trademark in the United States Patent and Trademark Office, because there are a lot of sellers that play games with that. Or I shouldn't say a lot, but there are some sellers that play games with that. And so there is a process for getting brand registry after you file.
There you go. Always look for a professional whenever you try to do something. Don't assume. So that's key. Yeah. Because Rich is doing this on a daily basis. So he's probably not Rich particularly, because your expertise is
my colleague Julian. Exactly. My colleague Julian, who handles all the trademarks for our firm, and yes, on a daily basis.
Yeah. So you're an expert in patents. I'm gonna shift the conversation a little bit to patents. That's a different horse, so to speak. I don't want to say something wrong, but it's totally different when it comes to actually patenting a product. How can people look at the patent, and how hard it is to apply for a patent?
Okay. Well, it's fairly straightforward. It's really, applying for a patent is a matter of explaining to the United States Patent and Trademark Office what the invention is, in a way that convinces them that it's worthy of a patent. So it's simple, but it's not easy, right? So in general, filing a patent application is a complex item. It involves a lot of careful, concise writing and drawings which demonstrate the product and how it works, and essentially why it's worthy of a patent. But once you file the patent application, eventually it will be reviewed by the United States Patent Office, who will either accept it or reject it. And if they accept it, then it gets granted as a United States patent. And if they reject it, then we have an opportunity to respond and fight the rejection. And most of the time, we're able to get those approved as well. But in a nutshell, that's the patent process. That's how you get a patent, and that's how you apply.
That's great. But when should we apply for a patent?
Okay, well, there's some important deadlines when it comes to applying for a patent, and most sellers don't know about this. Most entrepreneurs don't know about this. And the fact is, in the United States, if you haven't applied for a patent within 1 year of the first time you publicly disclosed it, then it's too late. There are still many ways to lose the rights during that year. So it's not advisable to wait the year. It's most advisable to file before you launch. But it's kind of like a worst case that you haven't filed and a year goes by, then it's too late. And so that's an important thing to know. And actually, in other places around the world, it's what's called absolute novelty, which means there is no 1 year grace period. So if you haven't applied for a patent by the time you launch, it's too late. So if you're concerned at all about international rights, or you want the possibility of obtaining patents in other jurisdictions, then you definitely want to make sure that you file your patent application before launch, before it's public.
Before actually you put your product on Amazon, on any website whatsoever. Right. That would mean
in public in any way. Correct.
All right. So you have to work in your garage until you're ready.
Yeah, exactly. And here's the thing: not every product is worthy of a patent. Not every inventor, not every seller should be applying for a patent on every product that they produce. But the time to do it really is when you launch. And so, at the very least, you should carefully consider: do I ever plan to do a patent on this at that early stage, so that if it is something you want to protect, you do it at the right time and you don't let it get away from you.
So basically, people should reach out to you when they have the invention and they're not yet live. But still, if they're live with the product and they're within the 1 year period, so to speak, it would be a good idea to reach out to you just to. Am I understanding this correctly?
Yeah, I mean, it's not the best situation if you've launched already, but not quite a year has gone by. But yes, it's still often possible for us to apply for a patent. So if you've already launched and a year hasn't gone by, then it's not too late. Keep in mind, it takes time to have us do a patent application. It's usually several months. So you don't want to contact us 2 weeks before your 1 year is up, because I just won't be able to help you. But yeah, in general, keep that in mind. And also, again, the fact that if the best scenario is to file before you make
launch.
Yeah, before you launch.
All right. Is there? I know there are two types of patents. I don't know much about this. I don't want to claim that I know anything, but I know there are utility and design patents that you can apply. Is
Correct.
that something you work with the seller and with the inventor actually to identify which is better? And
yeah, absolutely. I mean, usually we start the process with what's called a patent evaluation to get to know what they have, do some research on what else has been created that's similar, and then from there recommend approach and strategy. Like, what type of application should we consider? What are the costs involved in that? And so yes, we do help them make that choice. But just a little understanding of the different types available. So there's a utility patent and design patent. Utility patent is for the function and the structure. It's really for what makes the invention distinct from things that have come before for a functional reason. So you have a better way of making a certain product. You've like new features that make it function better. That's what a utility patent is for. A design patent is simply for the appearance of the product. So it's the what they call the ornamental appearance of the product, but that's all that's being protected is that. And that's still valuable on Amazon because often people copy you very closely. Like they'll make a product that's near identical. They're not getting inspired by your product and saying, wow, let's create our own version of this. They're just copying yours, in which case the design patent will be a valuable tool for shutting them down. So, and then there's just one further type of application. It's a provisional patent application. Sometimes people say it's a provisional patent. That's not really true because it's not a patent. It's just an application. It's just a step. It's a stepping stone towards a utility patent. So you can file a provisional patent application that is a little bit less formal than a full patent application. So it can be done somewhat less expensively. That then gets you priority toward getting the patent. So you file your provisional application. You have a year to file your utility application. So it kind of stops the clock, especially if you have that public use or a publication issue going on, and you want to make sure you get filed. You can file a provisional patent application as long as it's well written and well expressed. That will stop the clock on that. What they call time bar, meaning you're like being barred from getting a patent because you've been selling it publicly. It'll stop the clock on that, and it will also get you ahead in line toward getting the patent. So if someone else sees what you're doing and tries to file their own patent, well, you'll be ahead of them with your provisional. And so then you'll be relying on that provisional. And that's why it's important that it's well done, because that would be an angle for them to attack, for them to try to get the patent ahead of you, is to say, well, yes, you might have filed your provisional before me, but it wasn't very good. So that's, so really those are the possible options, is a utility patent or design patent. And you can take a step toward a utility patent with a provisional application, which then gives you a year to do the full utility.
No. And when you file, I just want to understand this one for myself. When you file the provisional patent, then you can launch, or you still have to be not public, so you have to keep it close to your heart.
If you file the provisional application well, like I said, if it's done, like, here's the thing with provisional applications, it's not reviewed by the government. So a lot of times people just put together a few paragraphs and file it as a provisional, and they say, I'm patent pending, I'm protected, but they're really not. And nobody's going to tell them that they're not. In other words, the patent office isn't going to say, well, this application isn't really clear. They just say, okay, here's your filing receipt. You were filed on that day. So really what it gives them is a false sense of security that they are protected when they're not. So the point is, like, as long as you have the provisional application done well, you could read into that as done professionally, then you are protected. You can launch with a provisional application.
Okay, that's clear. Makes sense now. Thank you. All right, but all these trademarks and patents, Rich, what are they good for? I mean, how do they actually help a brand? That's one part, to protect the brand,
right?
But when is their value really measured, so to speak?
They become most valuable when you get to exit. So having an IP portfolio, which is just another way of saying having a bunch of patents and trademarks. So having an IP portfolio will increase the value that you get at exit. If it's good IP, it can increase the value significantly. If it's kind of just lousy IP, it's like, okay, you got some IP, but it's not really that great or relevant. It will still increase the value. So it's really impossible to not get an ROI on money you spend on IP when you get to exit. And not every business gets to exit, but keep that in mind. That's where you will gain the most from your IP. It could give you a 10-time ROI with kind of lousy IP, and it could give you as much as a 200-time ROI on the money you spend on IP. If you get strategic IP, if you get IP that actually prevents competitors from doing anything similar, then someone acquiring your business will look at that as like, wow, there's some real barriers to entry here. So this is something significant that we're purchasing. It will increase the value significantly. You can get millions more because of the IP that you procured.
Yeah, at the end of the day, actually, most of the businesses are being built, not most, but a lot of them are being built for the exit and that cash day, because as Amazon sellers, we don't have so much money in the bank. It's always en route in store.
My friend Scott Dietz from Northbound Group says something that I really like. He said that more than 50% of the profit you ever make from your business, you'll get at exit. So each year you're trying to get a certain amount of money. You're trying to make a profit from selling your product for more than you spend in expenses. And so, like maybe you can make a couple $100,000 a year as profit by having a healthy selling account. But then, you might make a couple of million when you exit that same brand. So again, it's like more than 50% of the money that sellers get at that sellers make on their business, they make at exit.
Yeah, that's very important and so true, because that's the big payday that every Amazon seller is waiting for. But if you can influence that payday with good trademarks and also well done patents, that's a huge bonus to that payday. So you get even more. So why not?
Exactly.
Makes sense. Brilliant. Rich, that's very, very intriguing, and thank you for all those explanations. For me, it's clear that I have no idea what I'm doing, so I have to work with professionals. So I am your client anyway. So we're working together, and
right.
disclosure.
And I've got a book for that too.
Oh, there
if you
we
want
go.
to understand more about patents.
Yeah, but at the end of the day, you can understand more about patents, but when it comes to applying them and also creating a good patent and filing a good patent, I always recommend working with a professional. So,
Absolutely.
How can people reach out to you? That would be the best question. Or what do you recommend to people?
Yeah, I mean, if people want to learn more about the patent process, you go to my website, goldsteinpatentlaw.com. And there are helpful videos there as well. And also, I have a podcast, Innovations and Breakthroughs, that's available wherever podcasts are streamed. I've got the book that I just mentioned, which is the ABA Consumer Guide to Obtaining a Patent by me. It's a great plain English guide to help you understand patents better, not to do them on your own, but so that you can make good decisions with your patent attorney on what you do and when you do it. And if you want to set up to talk to us about the possibility of working together, you can go to ip4amazon.com.
Okay, that's also very important. And also I got this website.
Yes, and that as well.
Conversation.com.
Correct.
Okay.
That's so you can go to patentconversation.com. It's actually like really the same thing as IP for Amazon. So yes, if you want to kind of talk with us and find out if it's a match to work together, you go to patentconversation.com.
Got it. All right. So that's perfect. Everyone, I'll make sure to add in the description below also all the details about how you can stay in contact with Rich and also get more familiar with what Rich is doing behind the scenes from his book by the patents the patent information. And also feel free to reach out to Rich for any question or concern. Conversation is always the icebreaker. So Rich,
absolutely.
Thank you for everything. Is there anything else you'd like to tell everyone, or we've touched base on pretty much?
Well, I mean, I think that everyone at intelliRANK is awesome. They're some of the nicest, warmest people that I've met in the Amazon space. And when I met them a few years ago, I just immediately liked them. So So I
Thank
guess
you.
I'll add that.
It's right back at you, and yeah, we're looking forward to meeting somewhere in the world. Who knows at what trade show, what or party. Yeah, I just want to mention one more thing. Rich throws the best parties in Vegas. So if you're attending Prosper or anything in between in Vegas, or not only Vegas, also we Rich threw a great party with Accelerate in Seattle. So Rich, tell us a little bit about that. Just a disclosure.
Yeah, I love to throw parties at different events because it's really a great way to connect with people, and I'm a connector. I love connecting people that then become friends, that then start working together. And how do you scale connecting? You throw a party and you
There we go.
bring people together and you let them all connect. So I love throwing parties. If you want to kind of know when I'm announcing the next party, just follow me on Instagram. That's at Rich Goldstein, and I always announce there when I launch tickets and invites for one of the parties I'm throwing.
Yeah, I'll put that in the description as well. And yeah, also there's no party without a good tequila, Rich. So thank you for the tequila.
Yes, well, yes, that's something that we do. Is at the last party in Prosper, we had 20 bottles of 𝗏𝗂𝗋𝗄𝗎 in 1942, and we had a tequila tasting bar upstairs in this big suite where the party was, and we will continue that tradition of the tequila bar. So
We're
yeah,
so looking forward to that. Yeah.
awesome.
Brilliant. Thank you, Rich, and thank you for all the information you've shared with us today. For everyone that's interested, I will put all the information in the description as well. So reach out to Rich and his team and stay connected with the good side of things, so to speak. Yeah. Thank you, Rich.
Thank you.
Until next time. Bye, everyone.